This is the third video of our little series looking at powers of attorney, and we're continuing on with the PowerPoint presentation, and we're at the slide that's entitled Abuse and Misuse. We've reviewed some of the misconceptions of donors and attorneys, people who give the power, the donors, and people who receive the power, the attorneys, the substitute decision makers. But I wanted to talk us through a little practical case study to talk and show us a little bit about how complex it can actually be in the real life. Well, we know that attorneys, the people who have been appointed the substitute decision makers, have an ethical and legal obligation to ensure that they don't mingle money and that they don't use the financial power for their own personal gain. Seems easy, but it's quite hard. It really means setting up separate accounts, running the money in a completely separate fashion. And most of your clients and patients may not be completely aware of all of the accounting and bookkeeping that they're going to have to do if they're acting as an attorney. If they did know that, they might not want to do the job. But let's talk through a little case. Okay, we have a widower, Michael, and he has a daughter, and his daughter's name is Cindy. And Cindy is 45 years old, and Michael is 85 years old. And they have a good relationship, a very close, good relationship. Cindy has a son, Alex, and Alex is about 15 years old. Everyone gets along very well. So this is not a particular case where we're concerned about abuse. This is not a case where people are trying to do a bad thing. This is a case of real people trying to struggle. Michael is a widower. His wife has predeceased him for many years, and he has a diagnosis of dementia. Cindy offers for Michael to move in with Alex and her son. It would be the three of them, and they could modify the downstairs basement suite to make it elder-friendly. Michael loves this idea, and they work together to make it so. They invest some money jointly in changing the suite. They put about $5,000 into it jointly. Michael pays for some, Cindy pays for some. She was happy to upgrade some of that space anyway, and Alex pitches in and helps where he can. It's all a very positive story. But then Michael's dementia gets worse, and soon it becomes clear that the powers of attorney for personal and health care are going to come into play. We know that Cindy's starting to make the decisions for Michael, and he has had an assessment of incapacity for making some health and treatment decisions. We also know that Michael has lost some of the financial decision making that he has before, and has had a capacity assessment, and it's pretty clear that he doesn't have the ability to understand and appreciate aspect of his finances anymore. Michael, however, has been very clear before his diagnosis of dementia, before his determination that he had a capacity challenge. He didn't want to live in a long-term care facility. He did want to live with family. In this particular case, was very happy with Cindy and Alex. So Cindy starts running the money. She does a good job. She keeps the books separately, and she tries her very hardest to make sure that the money that is Michael is being used for his care and upkeep and well-being. But disaster strikes. Cindy is a single working mom. She doesn't have a lot of financial resources on her own. The roof needs repair, and it's a significant repair. And it's not a repair that Cindy can afford to make on her own. She believes that her father, Michael, would want to continue living in his suite, and they can't continue to have Michael live with them unless the roof gets repaired. Can Cindy dip into Michael's accounts? Can she lend herself the money? She believes it's what Michael would want, but she can't act as both the attorney for Michael and the recipient of that money. She's in a conflict of interest. What if Michael or Cindy came to you? Michael may not have a full ability to understand and appreciate, but he's able to talk and maybe express some wishes. Cindy is able to fully understand and appreciate the problem, but doesn't know what she's supposed to do. Alex is underage. He's not a capable adult, but having said that, his input does continue on to the fact that he speaks quite a lot with Michael, and Michael has expressed values, wishes, and beliefs about what he likes, what he doesn't like, and his different living experiences. So we have different pieces of information, and we have a puzzle. Cindy doesn't know. Can she use money from Michael's accounts? Can she lend herself the money? Can she give herself the money? She also knows that she is going to inherit the money, and Michael has more than enough money to cover, she feels, the roof repair as well as his future expenses. What do? Well, this was a real case. And in this particular circumstance, they actually had to go to court to get directions. This is a practical, if somewhat difficult and expensive approach. Cindy didn't know what to do, and she knew that if she lent herself the money, she'd be acting in a conflict of interest. She would be. She can't take that money. It's not hers. But she couldn't get instructions either from a substitute decision maker. She was the substitute decision maker. Now, if the power of attorney document had a backup person, it might be on a practical level that you could have Cindy recuse herself from that decision and it go to that backup substitute decision maker. So in that case, it might be if Cindy can't do it for some reason, then it's Michael's friend Bob. So maybe Bob can be looked to make that decision. In this particular case, though, there wasn't a Bob, and they did have to seek directions from the court. You might be able to talk to somebody at the Public Guardian Trustee's office and see if you could get some advice about it from that level. But this is an example of some of the practical decisions people have to make when they are acting as attorneys, and in this case, caregivers as well. Let's move on to the next slide, which says advanced planning overall. I don't know how many times on a practical level you're going to say this to your clients and to your patients and the people that you're supporting. Advanced planning, whether it be advanced health and personal care planning or advanced financial planning, has nothing to do with wills. So they may have done their will, they may have appointed somebody to run their estate, that would be called an executor, or they may have picked somebody to hold monies for them and distribute the monies, could be a trustee, has nothing to do with wills. So if you refresh your memory back to that square that we talked about at the beginning of the videos, where you have a capable adult up in the one square and below it's you get to decide, and the other square it's the incapable adult, and underneath it there's the list of who gets to decide. The court-appointed guardian is always first, and then there's an attorney, and then for health there would be a default list, and for finance there's no default list, it goes to the power of attorney. The last end square, the final line, that's the point of death. And so if they have a will, and if you need to explain to them and you draw out this little map, put will or death on the other side of it. And be clear, advanced planning is for a capable adult to make decisions for if they become incapable. A will is a very, very, very important document to have. But because they have a will does not mean that they also don't need powers of attorney or a plan around it. You see here in highlights it says, choose your best substitute decision maker based on appropriateness, not emotion. That's something that I think you can tell your clients and your patients time and time again. Think about what the attributes are and think about who can do it or what. Now, I'm going to spend a few minutes just quickly moving through what can be done about abuse and misuse. We know that if you move along into the section called civil law, there can be orders to freeze assets. Police can kind of get that, but in civil law, this is a case where you go to a court, you go to a judge and ask them to freeze the assets. Well, we know it because it can be very difficult if there has been abuse pursuant to a power of attorney or some other kind of financial abuse matter to get the assets back. People often move them, wire them, spend them. There are, however, breaches. A breach of fiduciary duty is one. You can rely on that if you have to go to court, that if the person is acting as your attorney and they've taken money, then it is a breach of fiduciary duty. It can be a number of other forms of breaches as well. Again, on a practical level, if someone's taken the money, it can be very, very hard to get it back. A really useful resource a lot of people don't know about is the Ombudsman for Banking Services and Investments. And obsi.ca is the website, and they can make recommendations for amounts up to $350,000. This is a case where, in some instances, there'll be the involvement or perhaps misinvolvement of a financial institution. Right now, Royal Bank and Canada Trust for the banking sections are not part of this. They use another ombud service called ADR Chambers, but all of the investment community does use this, including RBC and TD Investments. And they are a system for which you can have the person complain to the financial institution. And if the financial institution has done something wrong and it doesn't get resolved, you can then complain to OBSI, and they can actually argue for restitution. They can argue to get the person's money back. How would this be? Well, in the case of Michael and Cindy, if Cindy had gone to the bank and put on her, if you will, power of attorney hat and acted as her father and transferred the money over to herself, and the bank allowed that to happen, that would be wrongdoing on the bank's part, as well as wrongdoing on Cindy's part. And you could complain to the financial institution if you were trying to make it right. And if the financial institution doesn't fix it, you can then complain to OBSI. You don't give up any of your rights to sue. Your matter just becomes suspended, and the investigation can be ongoing. There's some more information about the contact details of OBSI. Lastly, I want to talk about criminal law. For advanced care planning, we're really looking at the property aspect mostly. We know that there is a section of the criminal code called theft pursuant to a person holding a power of attorney, section 331. There's also different areas of fraud and extortion and conversion, all of which are financial ways of saying that something shouldn't have been done with your money. So you can call the police, and the police can do an investigation. And in some cases, the police may be able to assist you in freezing assets or trying to get the money back. On the other hand, it can be very difficult to work with the police, not because they don't necessarily want to, but a lot of police officers are not well trained in elder abuse and may not be able to deal with it from a financial fraud point of view in an easy level. There are cases where it's been working very well and cases where there haven't been as well. Under practical considerations, look, what we know is this: prevention is the key. It can be very expensive to hire a lawyer. I've tried to give you information about how to move forward with advice that doesn't cost money. Having said that, what we know is that if a person is vulnerable or incapable, they often have a very difficult time instructing counsel. And if the person they trusted most is the person who's financially exploited them, it can be very difficult to try to fix that and to get that back. And that concludes our mini lecture series on powers of attorney with a focus on financial issues.